assignment that's due today, the Supreme Court cases. So if you're following along, it's part of the packet that I gave you. There's a couple of pages it's a big chart that you're going to fill out. Today we're just going to go over the first half, which is the first couple of pages from Marbury versus Madison to Abington versus Schempp. We're just going to cover those cases today, and then on Monday you're going to finish up the Supreme Court cases. So I'm going to go over each one. You guys who are watching live with me, if you need me to slow down, if you're writing, if you're trying to take notes now, just have me slow down a little bit. If not, you can always go back and look at the recording and follow along that way. And of course, if you got any questions, just stop me or type them in the chat box, and I'll help you guys out. There's also a digital copy. So if you go, I'm going to try to do this and hopefully I won't screw anything up. If you go to our website, if you go to our website, assuming everybody can see that, go to our website, go to today's assignments, click on the link. All right, down here, there's a document, Word document. It looks like this. So here's the chart. Can everybody see that?
Yep.
It's online. So this is the one from online, or you're using the paper copy that I gave you in class. And today we're only going through the first half. So on Monday we'll do the second half. But if you're doing it on your own, notice in the digital version I give you links to each case. So you could go straight to the page that gives you the information. So you can use that, or you can just handwrite it in the paper version that I gave.
Yeah.
All right, so Taylor, go ahead and mute your mic, and then if you need to ask me a question, you can turn it back on.
Okay.
All right. All right, guys, so the first three cases, of course, are already done for you, but I do want to kind of highlight some things about these cases, because these first three cases, the Marbury case, the McCulloch case, and the Gibbons case, they basically kind of set the stage for the power of the Supreme Court and the power of the federal government. If you go back and remember in early American history, there was a debate whether or not the state governments should be more powerful or the federal government should be more powerful, and who should make all the decisions. And what's crazy is that we're kind of going through the same thing now, right? If you've been keeping up with the news, you know, this idea of opening the country back up. Well, you know, President Trump and the federal government, they want the country to kind of get back to normal sooner, but the states are kind of resisting that, and they're basically going to be doing their own things in terms of deciding when those states should open up. So even today, we've got this argument basically between the federal government and the state governments about who's making the decisions. So if you go to Marbury versus Madison, our first case, the main thing there is to understand that that case is the one that established judicial review. And judicial review is that power that the Supreme Court has to look at cases and look at laws, look at decisions made by the president to decide if they are constitutional. So that's a very important case in terms of establishing the power of the Supreme Court to look at cases, to look at things. McCulloch versus Maryland. So this is a famous case that really put the national government versus the state governments into play. Basically, the story is the national government created a bank, a national bank, and the bank was located in the state of Maryland. And Maryland wanted to tax that bank just like it would tax anybody else within its borders. So the Supreme Court had to look at whether or not Congress even had the power to create a bank because it wasn't specifically in the Constitution, and then whether or not Maryland could tax that bank because it was sitting there on their land in Maryland. And what happened was the court said, for one, Congress could create a bank because there are some things called implied powers. Because of the necessary and proper clause in the Constitution, it gives it extra power that it needs to fulfill its duties. And then the second part of that was that no, Maryland could not tax the federal bank because of supremacy. The federal government is supreme over the states, so that means that you can't tax a higher power than you. So states can't tax federal institutions, even if they're sitting on their land, so to speak. And then finally, the Gibbons case had to do with commerce and who had the ultimate authority to regulate commerce, which is basically business, especially businesses that cross state borders, state lines, which this particular business did, being a riverboat, steamboat business. And ultimately, the court said that Congress has the ultimate authority in the Constitution to create laws to regulate businesses. And that's called the Commerce Clause in the Constitution. So those cases were already done for you. You should already have notes on those cases. But I did want to highlight those because they are important. All right. So the next case, and this is where if you're taking notes, you want to start taking some notes here. Tried to shorten up what you had to write there. So the Korematsu case is very famous back during World War II. We all know after Pearl Harbor, America decided that for national security reasons, they were going to restrict the rights of Japanese Americans and put them in these camps where they would live and be monitored during the war. And of course, being Japanese American citizens, they felt that they were being discriminated against, rightfully so. So Korematsu was one of those individuals who challenged this encampment policy, and it made its way to the Supreme Court. So the issue there is, did the President and Congress go beyond their war powers in restricting the rights of Japanese Americans? So was that constitutional or not, what they did? And basically the court said that it was constitutional at that time, and because the president needed to protect the United States from spying and other wartime acts, that outweighed the rights of those individuals at that time. Now that's surprising because today we wouldn't expect something like that to happen, but back then, I guess because of the fear of what was going on after Pearl Harbor, you could probably say we overreacted. But that's what happened. Now today we look back on that case as a mistake, that it was wrong for the court to uphold that decision. And in fact, I believe back in the 80s, the families of those Japanese Americans who were impacted actually got paid money. We call that reparations, as a way of apologizing for what happened to them during World War II. So that's Korematsu versus the U.S. And notice that the cases on this first page, they all have something in common. They all have to do with the power of the national government. Okay, so we tried to lump all the cases in a common theme. So on this first page, it's about power, about government power. So I'm gonna move on. And remember, let me know if I'm going too fast. If you need to stay on a particular slide, I will. All right, Nixon versus the U.S. or U.S. versus Nixon. This is the famous case about Watergate, the Watergate break-in that occurred, and the president basically tried to cover up the crime. He withheld evidence from the courts, and that's what the Supreme Court was looking at here. So the issue was, can the district court order the president to hand over evidence in a criminal case, or can the president refuse the court's order? So the court asked the president to hand over some tapes, some conversations, some documents, and the president refused. So the Supreme Court had to decide, was the president right in doing that? And of course, we know that based on the rule of law, that the president is not supposed to be above the law. The president's supposed to be subject to the law just like anyone else. So this is what led to the president at that time, Nixon, resigning. He resigned from office because he was going to be impeached. He was probably going to be removed because he was not obeying the law like anybody is supposed to. So the president is not above the law. The president has to follow the law just like anyone else. We call that the rule of law. So that's the first page. I guess you could take a picture of it if you needed to. So I'm going to go on to the next page. So these next three cases we're about to look at involve civil rights and the 14th Amendment. So they all have that in common. So Plessy versus Ferguson. 1896, the story is basically Homer Plessy was an African-American man that sat in the white-only section of a train. So this sounds very similar to the Rosa Parks story, except it's in 1896 and it's on a train. So Plessy sat in the white section. So in 1896, things were segregated. So he was arrested for that. And of course, he had done that intentionally, just like Rosa Parks got arrested intentionally. We call that civil disobedience, when you break a law that you feel is unfair or unjust, like we looked at last week or before spring break, excuse me. So the Supreme Court basically heard this case and had to decide if the law mandating racial segregation on the train was unconstitutional according to the 14th Amendment. Okay, sounds pretty easy, right? Equal protection, you probably shouldn't have segregation. But in 1896, they didn't interpret segregation the same way we see it now. So the Supreme Court at that time legitimized segregation or upheld segregation and said that it's okay to live by this principle called separate but equal. So separate meaning segregated, equal meaning you still have equal access to do certain things. So the argument for segregation at that time was, you still get to ride the train, or you still get to use a water fountain. You still get to go to a movie, even if you're told to sit in a different part of it. So they called that separate but equal. And at that time in 1896, the Supreme Court upheld segregation, supported segregation, and allowed it to be part of the law. All right, if there's no questions on that. Fast forward to 1954, Brown versus the Board of Education, very famous case. A lot of people already know about this one. This is the case that basically ends segregation in schools, and it basically orders schools to integrate. So, basically you had African-American children being forced to go to these all black schools instead of going to, the white schools that might even be closer to their home. So eventually they file lawsuits through the NAACP, which is an interest group that you should be familiar with, that fights for the rights of African Americans. And the court had to decide, does the segregation of public education based on race violate the 14th Amendment, Equal Protection Clause of the 14th Amendment? And in 1954, the Supreme Court said, yes, it did violate the 14th Amendment, that you cannot have separate but equal schools. Segregated schools are inherently unequal. So that's why they ordered a stop to segregated schools. Now notice this case is only about schools. It's only about education. It did not end segregation in other parts of life. It took the Civil Rights Act of 1964 to put an end to segregation in restaurants and on buses and things like that. So Brown versus the Board of Education only ended segregation in schools. Make sure you understand that. It's a really nice day. A little chilly, but sunshine. All right, so like I said, 1964, big year. So by 1964, you had, Dr. King had done his work, had done his march, his famous speech, and eventually the federal government passed the Civil Rights Act of 1964, which tried to end, or it banned discrimination, segregation in all parts of life, restaurants, businesses, any business, everything. So segregation was supposed to be done with by 1964. Well, the white owner of a motel called the Heart of Atlanta Motel challenged this law because, he, being racist, wanted to only serve white customers in his motel. He didn't want to integrate his business. So he basically challenged the Civil Rights Act. So the Supreme Court had to decide, can Congress end discrimination and segregation through this law, the Civil Rights Act? Was the Civil Rights Act constitutional? And they said, yeah, the Civil Rights Act was constitutional. And they used the Constitution to support it, saying that because Congress had that power I talked about earlier to regulate business, to regulate commerce, then part of that regulation could be to tell businesses that they could no longer discriminate. So they backed up the power of the Civil Rights Act with part of the Constitution itself, the Commerce Clause. Congress can regulate businesses, and that includes telling them that they cannot discriminate. Heart of Atlanta Motel. So those three cases we just went over there all involved civil rights issues and the 14th Amendment. All right, this next case, so the next two cases we're going to cover today, and that's where we'll stop today, deal with the First Amendment. One's going to involve speech and one's going to involve religion. So Schenck versus the U.S., 1919. If you don't know what was going on back then, this was during World War I. So during World War I, Schenck was a anti-war protester. He didn't believe in war, and he didn't want people fighting in war. So you notice this blue pamphlet here. He was handing out these pamphlets telling men to refuse to register for the draft. And if you know anything about American law, part of our legal duty, particularly men, when they turn 18, they have to register for the draft. And then if they're drafted, they have to go fight. Well, he was telling people to not do it, to refuse to register. If you get called to fight, refuse to fight. So in a way, he was telling people to break the law. So he was arrested for that based on a law they had at the time called the Espionage Act, which meant that if you were aiding the enemy, then you could be arrested. So they thought that what he was doing was hurting our efforts to fight the war. So he was arrested, but he claimed that he had a right to free speech. So First Amendment free speech here, to tell people not to fight, not to register for the draft. So the Supreme Court looked at that, and they said that not all speech is protected. So because what he was telling people to do with his speech was to break the law, his law was seen as a clear and present danger. So that's a famous phrase from this case, that if your speech is dangerous and it threatens others, then it's not going to be protected. Okay. And they equated it to, yelling fire in a crowded theater if there's no fire, or threatening someone's life. Those forms of speech aren't going to be protected because you are threatening someone. So they saw his speech as being a threat to our national security because it was during a time of war. So especially during wartime, sometimes your speech may or may not be regulated more by the government. So that's called Schenck versus the U.S. And our last case of the day, Abington versus Schempp. So Abington is a school district, so it really should be Abington School District versus Schempp. And this has to do with religion in school, and the separation of church and state. So basically, this is about reading the Bible during school. So imagine you go to school, and in your first block, after the announcements, every teacher in every classroom is expected to crack open a Bible and read it to the class. Okay? And then basically, if you didn't want to hear it, maybe they'd tell you to go wait in the hallway while we read the Bible. Okay, so that's basically what was going on here. There's another case called Engel versus Vitale where it had to do with prayer, like a morning prayer at school. So they're very similar. But basically, this was challenged by, of course, some parents wouldn't want their student to be have to go through that. So basically, can public schools begin each day with voluntary reading of the Bible by a school staff member? And that's key. It's not like you reading your own Bible at school. That's fine. That's within your right. But should a staff member at the school lead you in some sort of Bible study at school? And we're talking about a public school, right? We're not talking about a private school that you pay money to go to. They can do their own unique things. You can have religious private schools. So we're talking about a public school, just like Smith. And the Supreme Court said, no, public schools are part of local governments and should respect the Establishment Clause of the Constitution, which is in the First Amendment, which basically says governments cannot endorse or promote religious beliefs. So they felt that by reading from the Bible, that was promoting Christianity, and that went too far, basically. So they felt it was a violation, and they ordered the schools to stop doing that and to stop the morning prayers as well. So those are the only cases I wanted you to look at today. I didn't want to overwhelm you. So the rest of them you will finish on Monday. I guess I'll probably do another session on Monday and go over those cases. So does anyone need me to go back over a case, or does anyone have any questions?
Nope.
Nope, everyone's good?
Mm-hmm. I am.
Oh, but that's okay. But y'all take care of yourself.
Okay, you too.
Let y'all go.